Hi, this is John Bryan. Thanks for joining me. And this is Freedom is Scary, episode number 79. I'm here in my Lewisburg, West Virginia office because my main office, the audio apparently hasn't been working right. I'm not sure exactly what the problem is, but I'll have to basically move my YouTube studio over here to this office and sort things out later. So hopefully the connection is working a lot better here. Basically, what I wanted to start off with here tonight is this really uplifting, I would say, ruling that we got from federal court here late last week. In fact, I think it was Friday. A lot of people have been following this case involving this drug task force here in West Virginia. This was in Putnam County, West Virginia, and yes, it's the case, if you've seen it, that shows the police officers who entered my client's residence by pushing in the air conditioned unit in the window and basically climbing through the window. And they were caught subsequently on hidden cameras inside the house, searching the residence, going through all the drawers, going through the bed, pulling my client's guns out of the closets and arranging them for display, photographing them, and then basically just leaving the entire place ransacked, leaving the guns out for the client to see. Imagine coming home from work one day and all your hunting rifles, your AR-15s, everything's basically laid out in your kitchen, maybe across your stove, your kitchen counter, as if somebody had just arranged them for photography. It wasn't you. You go and check your home surveillance cameras. You find that your outside camera, the wires have been cut, and you find your inside cameras, which were hidden. You find the footage, and then imagine that who you find inside your house. Those are police officers. Though I would, if you've seen the video, you probably would know that it doesn't even really appear to be police officers on that video because these guys are wearing grunt style shirts, jeans. Even one of them, or possibly more, had a pistol sitting in the front of the pants, basically, in a position that they call, appendix carry. If you don't have a holster, they call it Mexican carry. But so that's what you see on the video. Yeah, that is the case. Now, there are three different cases or three different lawsuits that were filed against this task force. And this is really the first of them. So the first case, we'll call the Johnson case, and this is the ruling that came down here late last week. The second case is the Dillon case, and then the third case is the case from the video, and that's the third and final case that was filed. So in each of these cases, this is a federal Section 1983 civil lawsuit. So you sue the individual officers. So all the individual officers who were involved were named in these lawsuits. Now, for the most part, they were the same people. There was maybe one or two differences. Some of the lawsuits have one guy that the others don't, and vice versa. Now, all of the lawsuits also include as a defendant the county itself. So in West Virginia, counties and cities are known as political subdivisions. And so the actual party to name when you sue a county in West Virginia is the county commission. So this is in Putnam County, West Virginia. They were all employees of the Putnam County Sheriff's Department. So therefore, one of the defendants in the case is Putnam County Commission. So you don't name the Putnam County Sheriff's Department or anything like that. The proper way in West Virginia, anyways, is that you name the actual employer, who is the county commission. Now, a lot of people don't realize this, but just generally with federal civil rights, civil lawsuits, the employer just isn't automatically liable for the conduct of their employees. So the city of Charleston, for instance, isn't by respondat superior, they aren't automatically liable for the actions of their employees, the actions of their police officers, which they should be, but they're not. So when you're suing a police department or a county or a city for civil rights violations perpetrated by police officers, you can't just say, well, police officer John Doe committed excessive force or an unreasonable search and seizure, and therefore the employer is liable for that. And that would be nice, because then you could go to a jury trial and you don't just have Officer John Doe as a defendant, you have, the city of so-and-so. And there would be a number of advantages to that. But that's not the way it was, the way it is anyways. So in order to find or to have a municipality or a county to be held liable in federal court, you have to prove what's called a Monell claim, a Monell violation. And that's what this ruling on Friday was about. So I want to discuss that and see how long that takes. I mean, there's not a whole lot to discuss about it. And then once I get through that, if I have a little bit of time left, the other thing that's been going on, obviously, is the Rittenhouse trial. So I'd like to just touch on that if I can. I'll try to pay attention to some of the comments. I'll try to see maybe if there's even trolling comments, maybe I'll catch it for once and delete the guy. But so far, so good. Looks like pretty much everyone's behaving in the comments. So thanks for joining me. And sorry I can't get them all up on the screen, but it's, as you know, if you've followed some of my cases or my videos, it's been a while since I've really been able to do much. And part of that is because I've just been so busy. Everything's been crazy with all the litigation right now and all the craziness politically. And then also, for some reason, our internet in the main town where I live and where my main office is, has just been horrendous. And it just hasn't been good enough to support really any live streaming whatsoever. So hopefully I'll get that situated and get over here more often where I can do this. But here is the ruling that came in Friday. So this is one of the 3 lawsuits against this task force. Again, you have the individuals named, you have the employer named, the county commission, and then we also have one John Doe individual named, and that is to be, a currently unknown supervisor. And what that has to do is something called supervisory liability. So I'll explain how difficult it is to establish liability against the employer. But one way around that, not around that, but another way to kind of do that in the same vein is to make the argument that there's a supervisor, or whoever's supposed to be the supervisor of the officer who engaged in the constitutional violation, knew about the conduct or should have known about the conduct and really, was deliberately indifferent to that did nothing to stop it. So that's why there's a John Doe in there. But primarily we're dealing with the specific officers that you see named there, and then the Putnam County Commission. So what they did is there's 2 different defense firms involved, which is not uncommon. So you have one law firm that's representing the county commission, and then you have another law firm that's representing each of the individual officers. Now, the defense firm that's representing the county commission in each of these 3 cases, I believe, filed a motion to dismiss in all 3 of them. And it took us quite a while to obtain service on all these guys. One of them had, left the agency and then, moved in with some group of guys, all of whom I'm told ride motorcycles. So it was very difficult to get close to that individual to try to get him served. Others claimed that they weren't properly served, that the process server who works for the county commission didn't properly serve them. I think there were some claims that, well, he put it in my employee mailbox and that's not proper under the rules, which is technically true, but stupid. And so we had to reserve due to no fault of our own. So I don't think I've ever had so much trouble actually just serving people, which is just, supposed to be really a non-existent problem. But meanwhile, while we're serving all these guys, the county commission who's a lot easier to serve, by the way, they file these motions to dismiss. So all of these motions to dismiss are basically, the same argument. Now there are three different cases though, but as far as the county commission goes, they're sort of the same. Let me take this off while I explain that. So the first case, the Johnson case, this involves a family and they're all basically at home and these guys show up. There's no search warrant. They come inside the house and you can read the complaint, but they basically come in the house without a search warrant. They, find what appears to be a dead marijuana or hemp plant in the son's space in the basement. But they sit everybody around the kitchen table. They make them open their safe. They take a substantial amount of cash that's in the safe. They take the guns that are in the safe. These are the allegations. You can read them. And they basically leave. They take the stuff and leave. No paperwork generated, no criminal charges generated. And that's sort of the common thread that you see in each of these three cases. And so, on that basis, you can do something that's called a Monell claim. And that's how you create this liability in the employer. So if there's a pattern or practice or official policy or even an unofficial policy of civil rights violations in a particular department, then that is actionable under the case of, it's a U.S. Supreme Court case from 1978 called Monell versus, I think it's Department of Social Services. And that's really how you have to do it if you want to establish liability against a department. And it's very, very difficult to do. It's very difficult to do because, while you might have a legitimate civil rights violation, maybe it's even caught on video. Let's say it's an excessive force case. You can file the lawsuit. You can sue the individual officer for the excessive force, for the beating, and then you can sue his employer, the city of Los Angeles, whatever. But then you can't hold them automatically responsible just by proving a civil rights violation. You have to prove that they had adopted some policy, whether it even could be tacitly, where they're just quietly adopted it and they're allowing it to happen. But there's some sort of knowledge, there's some sort of intent there. And so it's the policy itself. It's allowing the practice to continue. That is the basis for liability against the municipality. Now, another thing is that, there's a lot of talk about qualified immunity. I've talked about it a lot. Now, one thing about these cases is that while individual officers, they can assert qualified immunity, who can't? Well, the employers. So Putnam County Commission or City of Charleston or City of Los Angeles, whatever, they cannot claim qualified immunity. Just an interesting aside. But what they can do is do what they did here, and that is file these motions to dismiss, arguing that the plaintiff can't prove his case. And this is really, I think these are usually successful in civil rights cases because a plaintiff can state that in his complaint all he wants, that the city has an official policy, adopted official policy of beating people up, whatever. You can allege that, but you have to, there's got to be some evidence. Really, what you need is evidence of other instances. So other acts of conduct involving the same police officer or the same group of police officers, and how many do you need? I don't know. I mean, there are some cases saying that you can just do it with one under some circumstances. There are other cases saying, you need more than one. So it's a gray area. They're difficult claims to prove. So the other way you could prove it is if you actually, instead of just having instances of conduct, if you had actually an official policy or implementation of a policy of civil rights violations. For example, one of the only ones I think I've ever seen was a case that I had against the city of Parkersburg, West Virginia, where it was alleged or communicated to me anyways by some police officers that the mayor had actually held a meeting and said, all right, I want you to start beating people up. And I'm paraphrasing, but there was actual evidence in that case that there was, this meeting called and there was an official policy that maybe wasn't put into writing, but it was verbally conveyed to the police officers that we're going to engage in these, Fourth Amendment violations of using excessive force on people. But short of a situation like that, which I really don't expect to see again, you have to just research other similar acts. Here, it was sort of easy to tie several together because we had the one video that went viral on the internet, and then you had other people calling me, and more than these three cases as well. At the very least, these three cases, all of which have a lawsuit pending, to sort of work together to prove liability under a Monell claim on the employer. And so this is probably a decent case for it. And your usual case, if you're looking at excessive force, I mean, you're going to be lucky to find another case of that same police officer or officers using force against another individual under similar enough circumstances to really get that claim through. But this is a different case, and I think it supports our claim because you have literally, if you look back, I think you can find it on YouTube, but if you look back at, I think it was 2016, there was a local TV news report on this drug task force, the Special Enforcement Unit, and it was sort of a fluff piece. And the very first YouTube video I uploaded on this, I had included the clip of that on the end of it. Then they asserted copyright, and I ended up bringing it down just because it was a distraction, though I think it was fair use. But you can still look at that, and I still have a copy of it. But you can look at the TV news piece that they did in 2016, and they basically followed these guys around. They showed them knocking on doors in a trailer park. They did like a cop sequence where they're in the car with the main guy, and he's describing, his philosophy on fighting crime and all this. That was like 2016. So the idea of it was, all right, we have this drug task force that is going to be really effective because they're basically going to throw all the rules out the window, and they're going to, beat them at their own game, that they're not going to wear uniforms. They're going to, wear their guns differently. They're going to, they're going to talk to a lot of people. So, I mean, that was, I guess, sort of the idea. And as we would argue, and as we did allege in the lawsuit, that the whole idea of it was to basically engage in, civil rights violations, to violate the Fourth Amendment with no, leaving no paper trail sort of deal. And whether or not they actually were supervising them, the unit was created. And as we alleged, the unit did engage in all these warrantless searches, one of which we caught on video. So the motion to dismiss that they filed and that you usually get in these cases is basically that, look, Your Honor, almost all these claims fail. They're very difficult to prove, and the complaint doesn't adequately allege that that there was no official implementation of a policy. They can't point to anything in writing, blah, blah, blah. So it's that sort of stuff. And they basically got shut down on that. So I'm really happy about it. This is the first of the three cases. Again, this was the family where they came in and alleged to have taken the money out of the safe, all that stuff. But the claim against the county is really the same because this is the pattern or practice. This is the policy claim that they established this group. They let it operate with knowledge the whole time that there were going to be civil rights violations, which did in fact occur. So this is called a memorandum opinion in order, and it'll actually basically be published online. It'll be searchable. It'll pop up when lawyers in the future or researchers in the future type any of these search terms in. So this is the basic law behind it. Again, like I said, Monell claim, Monell versus Department of Social Services. That's the actual site. Actually, it's 1976. I was wrong. Said 78. But the political subdivisions are suitable defendants, but I read that wrong. Does not render them vicariously liable for the actions of their employees. Like I said, so a plaintiff must prove the existence of an official policy or custom that is fairly attributable to the municipality that proximately caused the deprivation of their rights. So a lot easier said than done. Fourth Circuit case law, which you specifically turn to here in West Virginia, a policy or custom for which a municipality may be held liable can arise in four ways. One, through an express policy, such as a written ordinance or regulation. That's going to be a rare case, as I explained. Two, through the decisions of a person with final policymaking authority. So that could really be like the case I told you about, like the mayor, for instance, if you're talking about a city. Three, through an omission, such as a failure to properly train officers that manifests deliberate indifference to the rights of citizens. Or four, through a practice that is so persistent and widespread as to constitute a custom or usage with the force of law. So Fourth Circuit, they're giving like four different scenarios there that the plaintiff has to prove one of these cases. Fourth Circuit also noted that although prevailing on the merits of a Monell claim is difficult, simply alleging such a claim is by definition easier. So motion to dismiss, basically the court assumes everything in the lawsuit is true. Okay, if everything in the lawsuit is true, they're able to prove all of that. Is that enough? And you'd be surprised, a lot of cases get kicked out at that level because you can't just allege like, all right, there's a written ordinance if there's not a written ordinance. So in this particular case, let's see, the court goes through, what we had claimed, and I think we included all the necessary language in there. And the court concluded that we plausibly state a claim for relief. So let's see, and they turned to a Baltimore case, which I thought was interesting. So in the Owens case, the Fourth Circuit case, the lawsuit survived when the plaintiff alleged that there were reported and unreported cases from the period of time before and during the events complained of that established that the Baltimore City Police Department had a custom, policy, or practice of knowingly and repeatedly suppressing exculpatory evidence. So the Owens case was an interesting case, and Baltimore is in the Fourth Circuit. It's in Maryland, obviously, so that's within the Fourth Circuit. So there's a lot of good cases out of Baltimore, such as there's some First Amendment cases out of there, and there's the cases where they were giving people rough rides. That one famous case that's all within our circuit here. And here's why the court ruled in our favor. So the plaintiffs allege that the SCU engaged in a practice of warrantless searches and seizures, and that the SCU has also committed other civil rights violations against other victims in Putnam County, including the incident captured on video in August of 2019. So this allegation, like the one in Owens in Baltimore, alleges separate instances that may buttress plaintiff's legal conclusion, even if they occurred after the specific event. Okay, so in other words, just the cases themselves and the three lawsuits that we filed, they buttress each other, and they can rely on each other to form the foundation of this pattern practice claim against the employer. And because the employer was arguing that wasn't the case, they have to show an official policy that was adopted. There is no official policy that was adopted. Let's see. The complaint's other allegations include that the county commission purposely established and operated the SCU and knew of and condoned the SCU officers' repeated constitutional violations. This alleges that the county commission was the moving force behind the constitutional violations, where it deliberately created a unit of officers who did not comply with procedural safeguards and engaged in constitutional violations. So there's another Fourth Circuit case, Bryan County. No, that's a U.S. Supreme Court case, Bryan County versus Brown. and quoting Monell, 436 U.S. at 694. So they denied the defendant's motion to dismiss in that first case. There's two other motions to dismiss that are substantially identical in the next two cases. So I would hope that those also get dismissed. Now, again, that has nothing to do with the claims against the individual officers. So several of the officers, and it's hard to keep track which cases which, have already filed answers. So I don't expect that we'll receive any motions to dismiss from them, because these cases are much easier to prove. I mean, we alleged a very, very specific civil rights violation committed by that individual officer. There's not going to be any way they're going to be able to file a motion to dismiss and get that kicked out. So they're going to be subject to discovery, where I'm going to get to take their depositions. They can take my client's depositions. We can exchange written information, interrogatories, requests for production, and then take it back to the court at really the next stage. It's kind of what's called the dispositive motion stage, or the summary judgment stage. And that's where, unlike a motion to dismiss, where the court just assumes everything in the complaint is true, and, is there enough there, assuming it's true to, for a case to exist. At the summary judgment stage, where this stuff is usually litigated, the court will actually look at the evidence. So the court will look at the deposition transcripts of the plaintiff, of the officers, and the arguments of the lawyers pointing to those depositions or transcripts, and say, is there enough to go to a jury? Is there enough to go to a trial? So is there enough to create this genuine issue of material fact that a jury needs to decide? Now, at the same time, what else gets taken up really at that stage? Qualified immunity. So whereas qualified immunity doesn't apply to the county commission, it absolutely does apply to individual police officers who are included as defendants because they were acting as police officers. So there's no doubt that they assert qualified immunity at the next stage, if they file a motion to dismiss at the next stage. Now, as I've explained in some of my videos about qualified immunity before, there are certain types of cases where it's more likely to have to litigate qualified immunity. And primarily those are search and seizure cases. So whereas excessive force cases are less likely, they're becoming more likely, but they're traditionally less likely to be subject to qualified immunity. But search and seizure has really always been subject to qualified immunity, because you get all these cases arising from criminal litigation. You have all these criminal prosecutions where the defense lawyers are arguing that they may have nothing else. And maybe their only defense is try to get evidence suppressed. So they're arguing that there was an illegal search somewhere. So there's lots of case law coming out every year at the state, at the federal level, different circuits on what searches, what the search and seizure law is, what searches are legal under certain circumstances. So the law is constantly fluctuating. And that is where it's more likely that a court is going to grant qualified immunity, because they don't hold police officers up to the standard of a lawyer or a judge or a legal expert. They hold them up to a standard of understanding the well-established case law, basically. So if it's a relatively recent case, in effect, there's generally a lag between when the case becomes law and when the courts expect police officers to be aware of it. Now, there's no bright line rule on how long that is, but just in practice, there's a lag. Now, in excessive force cases, if the allegation is that they had a handcuffed detainee that they beat the hell out of, it's going to be difficult for the officers to claim that they were unaware that this was illegal. Now, what's been happening, particularly at the Supreme Court, is if there's an unusual fact pattern, they can complain that the plaintiff's complaint didn't point to a specific enough prior case. So if it's something different, like you had the Casella case in California where the cops shot this woman, and in fact she wasn't a danger to anybody, but from their point of view, she had a knife and she was close to another lady. Now, in hindsight, that other lady wasn't afraid for her life, and she didn't think she was in any danger, but just based on what the cops knew. Now, qualified immunity was basically granted by the Supreme Court in that case, but that was an unusual fact pattern. Generally, in your basic excessive force case, it's not going to apply, but it definitely can apply in any search and seizure case. However, just anticipating that argument down the road in this case, the way I would expect it turn out is, let's just look at the case where it's on video. So we have a video of police officers in somebody's house. It's undisputed that there's no warrant. Okay, well, it's very, very clearly established law that the Fourth Amendment requires that there are no searches of our home, of our castle, without a warrant. Period. That's a presumption in the law. So if they search the house, that's undisputed. If they didn't have a warrant, that's undisputed. If they were acting under color of law as police officers, and that's undisputed, then it's on them to basically prove their conduct not unconstitutional. How would they do that? Well, they could come up with a warrant for one thing, but again, if there's no warrant, the only other way around it would be to argue that there was an exception to the warrant requirement, and that would be their burden to do. And that's why the strongest of search and seizure cases are always in the home, because your home is your castle. There's umpteen thousand cases out there stating that, the Fourth Amendment protections apply most strongly in the home. Their home is your castle. So they would really, the only exceptions are consent, which would have to be voluntary, or exigent circumstances, which is basically an emergency. Now, they tried to create a third exception in a recent Supreme Court case. They tried to create this so-called community caretaker exception, but luckily that was shot down by the U.S. Supreme Court here last year. And that wasn't, it was basically just, and I think that's what the court held, is basically, you're just arguing exigent circumstances, but you're giving it a new name, because the so-called community caretaking exception really only applied to vehicles, and that has nothing to do with the home. So, qualified immunity, no doubt, probably might come up in these cases, but if the evidence pans out the way it's alleged and believed to be, that you have a warrantless search, all police officers are expected to know that you need a warrant to search a house, period. So you'd have to do some pretty tricky legal gymnastics to try to come up with a situation where a police officer could argue that that wasn't clearly established law. So you'd have to get into the area of exigent circumstances or voluntary consent. Now, one spot they might be able to get some traction, who knows, there is really the defense that I anticipated all along. And that is, if you recall, if you've been following the case, the officers in this particular case, the reason they claim, and this is on case number 3 specifically, the one really they got caught on video. The reason they claimed that they were on the property after they were discovered is they had some paperwork, some civil service paperwork. So a civil lawsuit out of magistrate court, which is like small claims court in West Virginia. So generally your service consists of a summons and a copy of the complaint. In this particular case, this was from my client's landlord, and it was an eviction petition. So it wasn't an eviction order. It wasn't ordered off the property yet or anything like this. This was just the petition that was filed by the landlord, seeking rent that was unpaid and seeking to evict the tenant from the property. Now, it never was consummated. They ended up making a deal and the rent was paid, and the client ended up moving somewhere else. But they were there serving that paperwork. So I theorized early on that, well, they could claim that the landlord gave them permission to enter the property. And so maybe they claimed that they were just inspecting the property for the landlord. Now, the problem with that is 50 years ago, there was a U.S. Supreme Court decision, I think it was the Chapman Case, which said that, that doesn't fly. So a landlord cannot give permission to cops to search the tenant's property. And that even goes all the way down to hotels. Hotels cannot just generally give cops permission to search the hotel rooms. I mean, there are obviously exceptions to everything, and you're going to find a whole lot more exceptions to the hotel scenario. But the Chapman case in and of itself, that had to do with, the Prohibition era. There was a landlord that came up to a house that he had rented to some guys, and it smelled like mash, or it smelled like there was a moonshine still inside. And he was peeking through the windows, couldn't quite tell. He ends up calling the cops. The cops show up. To make a long story short, and ironically, the cop climbed in the window of the landlord's house in that case, and inside discovered the still. So then he waited for the tenants to come back. When he came back, he surprised them and ended up arresting them for the illegal distillation of moonshine or whatever it was. And that's the case from, it was like 1959 or something, US v. Chapman, something like that. I've posted on it before. But so that again, so look at this through the lens of qualified immunity. So if a police officer is going to assert qualified immunity, his argument is that basically an argument of ignorance of the law, or rather mistake of the law. So it's like, look, I'm a police officer. Hindsight's 2020. We have to deal with, things on the spot. When we're presented to them, you can't expect us to be legal scholars and also cops at the same time. So therefore, qualified immunity can be granted where, a law is not clearly established yet. So where it's, it's sort of a new case. It's, a reasonable cop, a reasonable person might not know that there was this new case that changed things. Now, if you're going to rely on, all right, the landlord said, say we want to search a house and we know who the landlord is. So as cops, can we go to the landlord and say, look, we want to search this house, and, will you give us permission to search the house? And maybe the landlord in that scenario hadn't been paid yet. Maybe hadn't been paid in 2 months, and wants to get rid of the guy. Says, what, it'd be great if you did find something illegal going on there, so I can get rid of this person. So can they do that? I mean, I can see cops doing that. I can see cops not thinking like, well, wait a minute, maybe we should ask the prosecutor's office first. Maybe we should ask our supervisor, or maybe we should get some legal advice, or maybe we should just research things ourselves, or look at our training materials or our policy manual to see if there's any legal guidance on this. They very well may not do that, and they have this idea. They think it's a good idea. They go to the landlord. They get permission from the landlord. They think they're basically pulling one over on the subject of the investigation here. But it turns out they got a problem after the fact, because 50 years ago, there was a Supreme Court case saying that is unconstitutional. So that may have been what happened here. I really don't know. As far as I know, it really doesn't matter. And that's the fact of it. If you have a warrantless search of somebody's home, then it's unconstitutional, period, unless the government officials who perform that search can prove otherwise through claiming consent or exigent circumstances. That's really about it. That's very, very clearly established. That's pretty straightforward. So, and again, if you haven't seen these particular videos, I believe in the description you can find a link to the original YouTube video that was uploaded. You can find a link to more information. I mean, I get asked about these cases all the time, including by cops. I mean, it's a fascinating scenario. I think it's while fascinating, it's also pretty scary. I think I still have no idea basically what discipline, if any, occurred. I think there was a public statement to the effect that discipline happened, but I look forward to finding out all of these facts. Somebody asked, can you give an update on the KCS mask lawsuit? I mean, if I do that, this video would probably get suppressed, whereas they're okay with me like bashing cops. I'm talking about search and seizure or whatever, but those words will probably get me another strike on YouTube. But there will be an update on that shortly. Basically, the next date, if you're following that case, the judge gave the other side till I think it was November 15th or 16th to provide all their written materials, which obviously isn't here yet. And then we have time to respond after that. So unfortunately, they were given more time to respond. So we're waiting for that to happen right now. Let's see. Let me move to the other thing. Let's see. I appreciate it, Chris. Great video as always. You're able to hit the broad strokes of the Alderson case. I'm not sure which case is that. Can't think of what case you're talking about right now, but let me move to the Rittenhouse case. I mean, that's really the case that everybody's been following, and I haven't been able to watch it as much as I'd like. Basically, just here and there at lunch. Not much at all. I've watched some of it live. I've watched some of it after the fact, but I did some videos. If you look at some of my videos from like when all this had happened and when he was originally charged, I did some videos on it that were pretty good. But it's a whole nother thing looking at this from while the trial is actually happening. And I think it's terrifying, really, because you have somebody. I mean, it's a self-defense case, and it used to be that, I mean, if you're in an altercation, and somebody is like actively beating on you or hitting you with an object, and especially if they're armed or pointing a gun at you, I mean, they're never going to bring that case. And here there's evidence that, I mean, this kid's being chased by a crowd. And now we've seen it from different angles. We've seen the FBI drone view, which is a whole nother video. But you have a whole mob chasing after this kid. He is physically attacked. He's knocked to the ground. You have armed people going after him. And I believe it was admitted today that somebody had pointed a gun at him. I mean, that's self-defense right there. That's self-defense. I can't think of a much better case for self-defense. And we all know that. The question is, I think, does anybody care? I mean, people care, but does the other side care? I think this has been about politics from the beginning, and it's just a shame. Now, I know a lot of people disagree just with the fact that this young guy was out there running around with an AR-15 on the streets of Kenosha. But if we think back to what was happening at the time, remember, you had all these riots going on. You had all this destruction of private property and, frankly, public property. And remember what the cops weren't doing at this time? The cops weren't defending people. The cops weren't defending people's lives. They weren't defending people's property. And so you had private citizens that were going out there and doing the job that the police were supposed to do. And in my mind, anyways, at that time, I think any debate about the Second Amendment by reasonable people really was settled. because you cannot depend on the police to protect you. You cannot depend on the police to protect your property. So like it or not, you had private people doing it. Now, generally, under most state laws, including in West Virginia, I mean, you're not allowed to use deadly force to defend property, to defend real estate, to defend personal belongings. You're only entitled to use deadly force to defend somebody's life, whether your own life or the life of somebody else. And that is this situation. So you have to separate, I think, the fact that he was out there defending this car lot for whatever reason. At the same time, if somebody's defending a car lot, just because they're armed doesn't mean that they've made any choice to defend that car lot with deadly force. So if you were to shoot somebody to defend a car, I think that would be a bad shoot under the state law. I think it's, as far as I know, only in Texas do they have somewhat of a defense of private property with deadly force law, and I think it applies at night. I don't think that's an issue in Wisconsin. Certainly wouldn't be in West Virginia. But if one is armed and they are attacked, then, or somebody else, some of the third parties attacked, then you're not defending property. You're not defending real estate. And that was the case you have here. It doesn't really matter why he was out there. He was entitled to be out there. The firearm that he had, whether you like it or not, whether it's scary to you or not, because freedom is scary, it was legal to possess, just like the case I litigated here, the Walker case. Yeah, a AR-15 in West Virginia is legal to possess, and it's legal to open carry. And as far as I know there were some issues with his age, maybe, but any one of those people there are allowed to, so long as they're not a prohibited person, they're allowed to possess a firearm. Therefore, if you have a firearm to defend yourself potentially, why not have the best one to defend yourself? The cops, you better believe, if they get out of their car and they go into a potentially dangerous situation, what do they bring? They bring their AR-15 out of their trunk. Kyle brought the gun across the state. I mean, I don't care about that. Those are unconstitutional laws, in my opinion. This is a self-defense case. The only issue is, was he in reasonable fear of his life or the life of somebody else when this happened? And, who knows what you believe if you believe everything the media tells you, but all right, what are the facts shown so far? All right, he was where he was allowed to be. Okay. He was where he was allowed to be, doing what any citizen was allowed to do at the time this kicked off. He was attacked by people. He was chased by people. There were gunshots going off. Some of the people chasing him were armed, at least one of whom pointed a gun at him. I think there was somebody who shouted something about giving him a cranium or implying that he should be shot in the head. Would any reasonable person fear for their life under those circumstances? And if so, what would a reasonable person do? If that reasonable person is armed with a firearm and has the ability to defend their lives, I don't even think it's a close case. And remember, in a criminal case, you're innocent till proven guilty. The state has to prove beyond any reasonable doubt that you're guilty. And in this case, I think there's just a grab bag of reasonable doubt there. I mean, you really want to set a precedent where there's somebody coming at you with a gun, or multiple people coming at you with a gun and physically attacking you, hitting you with a skateboard, and they could just beat you to death, but you can't defend yourself with the firearm that you have on you. And then you can take into account, well, what do it's not really different than police shooting cases. In the end, they're all self-defense. So what do the cops say? And this is a very real danger. All right. If you have a gun, the other guy knows that you have a gun and they engage you physically, they're trying to hurt you. Is it reasonable to assume that if they get that gun away from you, that they're going to kill you, that they're going to shoot you? Now, in this case, he had a sling. Now, one of the important things about a sling is that, well, not only is it convenient to carry, but it also attaches the weapon to your body where it doesn't fall to the ground. It can't just be pulled away from you easily. And that can save your life. And, but they could still get it away from them. Don't bring a skateboard to a gunfight. All right. I think this is the biggest hurdle for him. Yeah, he went out to a protest with a gun trying to intimidate the crowd. I don't think that that's accurate. I think the weakest part of the case is that he was there in the first place. Okay, why is he there to defend some car lot? That's not an argument that he's doing anything illegal, but it's going to be hard for some people, some potential jurors, to get past. Was he there to get into an altercation, or, as this guy's alleging, to intimidate the crowd? I think if you look at the video that I've seen, he's running around asking people if they need medical help. So I don't believe that the actual facts support that argument at all. I think the actual facts support, him just being young, and young people, being idealists and wanting to do what they believe is the right thing, that he had the courage to go out there and do what the police wouldn't do, and that's protect private property from this group of rioters. And the police weren't doing anything about it. So I think it's easily explainable, but it runs the danger of politics getting involved. Scratch off. Sorry, I didn't know this was a communist channel. What does that have to do with communists? I'm not even sure. Shouldn't you be calling me a fascist? I'm no idea what you're talking about. But that is a state where you're allowed to possess a firearm. He possessed a firearm. He got attacked. Therefore, he used self-defense. It seems like an exactly straightforward case of self-defense to me. The only reason that he's prosecuted, I believe, is because of politics. And, the media is demanding it. Certain politicians are demanding it. And it's really scary, but it looks like, at least, he's got very competent lawyers involved. It looks like the judge is highly competent, and that's great. But it's an interesting case to watch, and I definitely want to watch more of it. And I recommend that everyone watch it, because it shows just how scary that process is. It shows just how subjective it is, that it really does make a difference if you have a really good lawyer. If you can afford the best lawyer money can buy, or a really good lawyer even, or do you get the guy from, my cousin Vinny, can't not stutter. So it's sort of like acting, trying jury trials. It's highly complicated, and, you can train all your life at doing it. And it's very difficult, cross-examining witnesses and direct exams of witnesses, trial strategies. It's all highly subjective. And then you're talking to a jury the entire time who is not allowed to talk back to you. You don't know exactly what they're thinking, what their issues are. You're having to guess, and you guess by looking at their body language, by looking at their, what they appear to pay attention to. Are they shaking their head yes to a certain thing? Do they look angry? It's just crazy, if you really pay attention, how subjective all this stuff is, and the stakes couldn't be higher. This kid has the entire rest of his life at stake. So it's a scary situation, and I really hope that he gets a fair trial. And all that comes down to, really, it looks like the trial is being conducted in a fair manner. But what I really mean is that I hope that he has a fair jury. So let's see. Let's see. My state, you can have a gun at 16. Let's see. Come on, John. I know you want to laugh. Well, what was I laughing at? Everyone that carries should have some kind of carry insurance. The problem with insurance, and I'm not familiar with any of these plans specifically, but the problem with insurance generally is that it will always have a clause in it that says, if you commit a crime, we're not going to cover it. So, if you go rob a bank, they're not going to cover it. But, what if you're looking at self-defense situations? Yeah, we're not going to cover first-degree murder. But, what if it wasn't first-degree murder? What if it was self-defense? So that's always going to leave a gray area there where, a weaselly insurance company can try to get out from under it. Pearl Rival, do the police come after civil rights attorneys? Yeah, I've been asked that a lot. I don't have any personal experience really with the police ever coming after me. But at the same time, I don't put myself in that position, and AKA, don't invite the man into your life. So I'm sure many would if they got the opportunity, but I try not to give them the opportunity. I'm sure there's lots of lawyers out there who have. Jeffrey, attorney in Ohio. If you want to send me an email, again, this is my email. If you want to send me an email, I'll have to take a look at that. There's, off the top of my head, I've dealt with a few attorneys in Ohio. I don't know specifically. I want to say that Chris Wiest in Kentucky may be also licensed in Ohio, and if so, I would highly recommend him. He's been on some videos with me, and if not, I would ask him anyways and see who he recommends. Let's see. So, I'm going to continue watching Rittenhouse, and I'm going to, watch it some more. Maybe I'll do another video on that where I can pull some clips in. I think it's really interesting from a trial advocacy point of view. What is effective about this cross-examination strategy? What is this lawyer doing in his direct testimony that is effective? And it's interesting when you get down to those details, because you can see lots of things that you never really thought about before. What's effective and what's not effective. And again, it's like critiquing somebody's acting, but this is real life. It's not acting. It is, but it isn't. It is a performance. It's a performance by the lawyers. But again, there's high stakes. Chris, can you comment on the Alderson town mayor case? Oh, that's what you're talking about. No, that's a criminal case. So, excuse me, we'll comment about that in court. As we already did, but that'll play out in court. That's a criminal case, so won't be making any videos about that or going over it until it's all over. When it's all over, then definitely. The Keisha, the Ahmaud Arbery trial is another pivotal Second Amendment case happening now. Yeah, I'll take a look at that one. Pearl should post on this daily if possible. Nancy Grace, critical of the Second Amendment. I agree that this is critical to the Second Amendment. And this is really scary. If you drive through any area where you have, for instance, like a George Soros prosecutor, and there's quite a few out there right now, where politics really plays an important part in their exercise of discretion about whether or not to prosecute somebody, then you better believe if you get in the middle of a political mob, a politically motivated mob, who, like we had with some of these riots last year, then that mob might be able to do anything they want to you, including kill you, and you cannot defend yourself because you're going to get prosecuted for it, like Kyle Rittenhouse is. And that's an awful precedent to set. You can't allow any civil rights violation, even when it's being asserted by somebody who's unpopular. You can't disallow it. And this is a difficult part of my career, is ultimately having to explain to juries why, even though they may not like my client, why they should rule in his favor, because it's in their interest as well. And that's part of why, freedom is scary, because, you can't just allow the assertion of civil rights. You can't just allow constitutional rights where they're being asserted by a popular person or somebody whom you approve of. Because if you don't allow the assertion of constitutional rights by somebody who's unpopular, somebody who you don't like, or somebody who's really unpopular, then they don't exist. Because if there's any discretion at all in it, then they don't exist. And so we've allowed fear to come in. We've allowed politics to come in. There should be equal protection under the law for everybody, right? Whether they're a Southern Baptist or neo-Nazi, or insert unpopular political group, or whether they're a criminal, no matter what they did. If we're really going to defend and enforce the Constitution, we have to be consistent that it's enforced for everybody. Because if we allow even one exception, if we allow any exception, then it can, we have nothing. So if we allow Kyle Rittenhouse to be railroaded, even though he acted in self-defense, because it's the politically popular thing to do to many people, if we allow that to happen, then none of us have any right of self-defense. And that's just the way it is. I think that's why so many people have donated to the cause, that so many people have been passionate about it. And it's not that we fall under Wisconsin law, but there's so many people paying attention to this that if it's allowed to get by here, then we've got a big problem. Yeah, equal application of the law. And all right, so let's compare what's happened here. Let's compare what's happened here with January 6th at the Capitol. Not that I want to get this video knocked off the internet here, but compare what they've done. Like, they've gone after, 450 people. They've gotten like 100 convictions. None of them for insurrection, by the way. All just for mostly misdemeanors, unlawful entry of property. But let's look at the resources that were poured into that. And, what is the reason? Well, I think anyone being honest knows that it was politically motivated. And it's really no different that the prosecution of Kyle Rittenhouse is no doubt politically motivated. It can't be allowed. Look at the precedent that January 6th has set. Who wants to go to any kind of political rally? Well, not any kind, but who wants to go to a Trump rally? Say he runs again in 2024 in the Capitol. I mean, what idiot would do that? That has chilled the First Amendment. That has had a devastating impact on our constitutional rights. Just the way that they ruthlessly came after anybody there, even coming after school bus drivers who were nowhere near the actual Capitol. It was a scorched earth campaign motivated by politics. And here, the only person they can come after is Kyle Rittenhouse. And they've come after him scorched earth. Can you imagine what this kid has had to deal with? So that's pretty. I think that's we're about an hour and 4 minutes here, so went a little bit over. But I appreciate you watching, and hopefully I can get my audio visual situation sorted out where I can get back to making at least one live video a week. We'll see. And I have lots of other interesting cases that many of you follow that I need to give updates on. But again, these are cases that are ongoing, and I'm busy litigating them, and also dealing with a lot of the other stuff that's been happening this past year and a half. So again, thanks for watching. And remember, freedom's scary, and we cannot let the politically motivated people, we cannot let the Karens out there, just because of their motivations or because of their politics, we can't let them spread fear that will take away our constitutional rights. And that's why, freedom is scary, and we ought to like it that way. So until next time, again, I'm John Bryan. Make sure you follow me on the website at thecivilrightslawyer.com, and you can subscribe to email updates there. And also, if you're on YouTube here, subscribe here as well. And I will definitely see you next time.